Next up on This Week in Law, we've got Kashmir Hill from Forbes, Marty Schwimmer, and Evan Brown. We're going to talk about social media eyeglasses. What are you going to do when someone comes up to you wearing a pair of these things, streaming away? In Europe, they want a right to forget. And here at home, it could be a felony to take pictures of farms in Florida. Next on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 102, recorded March 11, 2011. Private Eyes. This episode of This Week in Law is brought to you by Squarespace.com, the fast and easy way to publish a high-quality website or blog. For a free 14-day trial, go to squarespace.com/TWiL. Hi, folks. Welcome to TWiL. This is Denise Howell, and we're here with a great panel today to talk about all things related to technology and law that happened this week and in the coming weeks. So we've got joining us today from Forbes and her not-so-private parts blog, Kashmir Hill. Hi, Kashmir.
Hi, Denise. Hi, everyone.
Great to have you back on TWiL. Also, a return visitor joining us again from the Trademark blog and his new firm, Leeson Ellis in White Plains, New York, is Marty Schwimmer. Hi, Marty.
Hey, Denise. How are you?
I'm great. Good to see you as well. And joining us, too, is Evan Brown from Hinshaw and Culbertson in Chicago and InternetCases.com. Hi, Evan.
Hello, hello. Great to see you.
Great to see you, too. So today is an interesting day for us all to be recording. It's a day where we're all in places that are less interesting than a lot of the places in the world at the moment. Of course, the earthquake in Japan on Friday afternoon, their time, which hasn't happened yet, my time, which is always a bit freaky. It happened last night for me, and we are just watching the aftermath of that, and our hearts and thoughts go out to all the folks in Japan. The images are rolling in even as we speak, and it's just devastating and awful. And we were talking about it before we started recording, and can't really go forward without mentioning it and just being sort of staggered by the scale of it. So there's that happening as we're going out here. And also on a lighter and completely different note, South by Southwest is taking place in Austin, which is near and dear to all of our hearts in the world of technology and the intersection of technology and law. And I have a little update from some former TWiL panelists and soon to be again future TWiL panelists to tell us about what's going on their panel there at South by Southwest. We've got Lisa Borodkin and Jack Lerner giving their talk at 3:30 Central, 1:30 Pacific time today. They're going to discuss and debate the Social Network Bill of Rights that they discussed previously on the show at South by Southwest Interactive. If you're interested, that's going to be as soon as we wrap TWiL, shortly after we wrap TWiL. You can check out more at snubillofrights.com, and a wonderful Twitter hashtag to follow today as they're doing all this is #Snubor, SNUBOR, to follow along with them. They're both going to be with us on April 15th to give us the debriefing from there. So hope they are having fun, and all our TWiL family who are also at, TWiT family who are also at South by Southwest are scrambling and having a great time there. We wish we were there. But we're not. We're here in our respective spots. Other places where interesting things are going on that we are not are, for example, in the EU and specifically in Spain, I believe. Kashmir, can you bring us up to speed on what's going on in Europe about the right to forget?
Sure. So the European Commission right now is talking about a new privacy directive, and one component of it is the right to be forgotten. And this means being able to kind of erase certain things about yourself on the internet or in particular databases. And it's starting to get moving already. There are over 80 cases in Spain of people who want to have things removed from their Google searches, links that go to something that's out of date or inaccurate. And the one that I focused on, and the Wall Street Journal focused on, is a Spanish plastic surgeon who who had a kind of, one of his patients had a botched breast surgery, and El País wrote a newspaper article about it and talked about how this plastic surgeon had been accused of malpractice, and he was later acquitted of that. But this newspaper article still shows up, and it doesn't talk about the acquittal. And so he asked Google to remove it. Google, as is their policy, said no. Google always sends you to the original source, so they say go talk to El País, who also refused to take this newspaper article out of their archive for. I mean, that's what news organizations do. And
right.
So he went to the Spanish Data Protection Agency, the Spanish privacy regulator, and they agreed with him and told Google that they need to help him and remove this link from his personal Google search. And there's over 80 other cases about this. And Google is fighting that. They're appealing it, and now it's going to move. The Spanish court is thinking about referring it to the European court, a higher court, to make a decision about this. But again, it just taps into this right to be forgotten and whether we should have more control over our reputations in the internet age, which is a topic near and dear to my and the not so private part's heart.
So what's going to happen to Google? I mean, they have to follow the local laws in the places where they're doing business. What's going to happen? I mean, the EU tends to be fairly restrictive about these kinds of things. It seems to me within the realm of reality that they could well mandate that Google start deleting things.
Yeah, it seems to me that would be the case as well. I mean, Google has different policies in different countries. In the case of, is it Germany, where they ask that certain searches not be allowed, so that if you're searching like for Nazism, they basically censor the search results. So they do make different policies for different countries, and they're fighting this one. Peter Fleischer, their global privacy counsel, had a really interesting post on his personal blog talking about how this challenges, free speech and who gets to decide what the public gets to know. I mean, if you were going to go to this plastic surgeon, maybe you would want to know that he was once accused of malpractice. So it's about whose rights are most important.
Marty, do you think this is relevant in the era where even if people are able to perhaps purge search results, there are going to be other sites out there that are reviewing and critiquing people like plastic surgeons? And you could, if you're doing your due diligence, you wouldn't just do a Google search on them. You'd also go to Yelp and see that this guy has terrible reviews, or Consumer Reports, or various other sources. Does this matter?
As a commercial matter, of course it's horrible. I think we've talked about AVO on this show, which is a directory about lawyers. And I mean, we live in fear, I mean, not lawyers, but any professional, where there's going to be a hard case who's going to be angry at you, perhaps in your view, wrongfully angry at you, and they're going to write horrible comments about you. So there's clearly this understandable fear about bad information. At the same time, as I'm reading about this article, I'm wondering, how could a newspaper article be private in any way? I don't understand that. And I also think that there's this logistical problem, which is once it's out there, it's out there. So isn't someone going to, copy that 91 article on the doctor and just out of spite post it on their site? So it seems like a and WikiLeaks would be the best example of
Sure.
the inability to get the cat back to get something back in the bag.
The genie back in the bag.
The scalpel
The cat back in the
back.
bottle.
Some mixed metaphor. You understand what I mean. But as I'm thinking about this, I'm also reminded about the last time I was on the show. I was complaining about how my 14-year-old son had an embarrassing photograph of him on Facebook, and I reminded him about how grandma was one of his friends on Facebook. And now I'm worrying about, colleges. He's getting to that age about his posting's going to be on Facebook, and I'm thinking, as a technical matter, the genie cannot go back into the bottle, and the cat cannot get back into the bag. It's out there, and that principle is enshrined in a lot of laws, in trade secret law, things like that.
Well, for people in your son's position, they're trying hard to put the genie back in the bottle. I'm not sure where I read this. Maybe Kashmir will remember or know what this is, where this emanates from. But I have been reading about colleges that, as part of their career planning, career placement offices, are providing to students, as part of their services, Facebook purging services. They can go through and see exactly if there's anything controversial, that a red flag pops up for anything that you have in a social media kind of context, and they help you clean up your act, as it were, so that there's nothing for employers. Do you know what I'm talking about, Kashmir?
I don't know particularly of that program that colleges are doing. I do know that there's an app called SocioClean, and it's something that you can run your Facebook account through, and it'll identify things you might want to take down, whether it's foul language or references to drinking or partying. And yeah, they advise that you go through before applying to colleges or applying for a job, and it goes all the way back, maybe things that you've forgotten about that are there.
Right. So that takes care of maybe your own house, but as far as the doctor's example, that's nothing that he posted on his own profile. Evan, any thoughts on this?
Yeah, sure. I mean, I have a little bit of aversion, if you will, to this notion of the right to forget and calling it that. I think that may mischaracterize what the real problem is here. And I know, just like net neutrality, that term doesn't fully encapsulate the notion of what we're talking about. Cognitively, I like to think of it as network discrimination instead of network neutrality. Excuse me. So along these lines, this notion of the right to forget, calling it that leads us astray a little bit from the real important issue here, which I think, even though we're seeing this stuff happening in Spain, with this litigation in Spain, and then in France, there's been some proposed legislation about a right to forget that we've talked about. Even though that's happening on there, and we think, oh, it's those crazy Europeans doing whatever they're doing, I don't think that the sensibilities are really that much different than those that we hold sacred here in the United States. And that sensibility is what underlies all of the law of defamation. And it's this: we feel some inherent right to have, or an unalienable right to have a true picture about us painted in the world. And, to the extent somebody says something false about you and that harms your reputation, that's actionable in a defamation lawsuit. So with this stuff out here on the web, I think to the extent that the things that are out there that are mischaracterizing a person or painting a picture that's misleading, there is something there that needs to be addressed. This, of course, quickly bumps up against the First Amendment, especially of the publishers of these sites. It's very unsavory to think about a court order telling Google or a web publisher, take this stuff down because it violates someone's right to be forgotten. There, I'm saying it. And so I don't know how to articulate what the standard should be, but I don't think we should deny this sensibility, and instead we should allow particular cases to help us draw the line of demarcation between a redressable right that is given life by this sensibility and the First Amendment somewhere. So I guess my caution is to not think that the right to be forgotten and what it truly means is something that we should just dismiss as crazy talk.
Okay,
well,
sorry, go ahead.
I was just going to say, pragmatically, when I look at this case, I wonder why El País won't just go back and add another link that says, okay, this malpractice claim was resolved and he was acquitted. I mean, that's what I want to do as a blogger and as a writer, that there should be some kind of, rather than taking things out or deleting things, that there should be almost an annotation system for the web where people have, for their own personal search results, maybe they get to annotate certain things. So
yeah,
I just want to throw more information at it.
Yeah, but I mean, remember, oftentimes people will think, where there's smoke, there's fire, and if there's an awful lot of smoke out there that causes readers or users to know something about someone, it's hard for them to subsequently unknow that, regardless of whether you're throwing truckloads of new information at them. They're still, going to be, after all, I can't believe that most of us might think that O.J. Simpson committed murder. I mean, can you believe, that, or so it's just like I say, it's hard to unring the bell.
Well, I don't know how we talk about this and not go straight into talking about Courtney Love and the fact that she recently, we alluded to this on the last show, paid close to $500,000 to someone who sued her over her tweets for libel. She, I guess, had a bit of a grudge against somebody who allegedly overcharged her for some dresses. She wrote a series of tweets basically saying some not very nice things about this person who the not nice things were apparently untrue. And Kashmir, you covered this, and you struck on a theme that has fascinated me ever since I started writing a blog back at the beginning of the last decade. And that is this notion that, as we become more and more public figures and micro celebrities of some kind, as you said, the defamation and invasion of privacy claims morph and change, and definitely the proof aspect of them in court becomes a moving target. Do you have any more thoughts about this Courtney Love case?
Yeah, I always have to come up with these things saying that I'm not a lawyer. I look at it kind of still philosophically. But I do think it's in this particular case, so it was a dress designer, and she had designed some dresses for Courtney Love, and I guess Love thought that they would be free, because I guess that's usually the way that it works in Hollywood. But then she got bills for them, and they were quite high, and so she got upset. And the immediacy of Twitter allows you to say things very quickly without thinking them through, and so she wrote some horrible things about her. But the woman is kind of a public figure. I think she goes, I forget her name right now, but she goes by
in your story here. Goodness, it's unpronounceable. Simo Rengiker.
It's like her
Dawn,
public persona is
Dawn is her first name. We can go with Dawn.
And her public persona, I think, is the boudoir queen. She has a website. She's very public. And so if this case had gone forward, I think one of the claims that Love was going to make is that this woman was a public figure. And I think there's a time when, a dress designer wouldn't be a public figure, but now we have all these micro celebrities, and within Hollywood, she probably is somewhat famous. So I was excited to see how that would be received in court, but since she settled, we didn't get to see that happen.
Right. Evan, do you think we would have seen any nuances here, or just a straight sort of defamation claim?
Probably a straight defamation claim. I mean, clearly, if Courtney Love was going to raise that as an issue, that issue would get addressed, but I don't think that they would have come out on the side of this dress designer being a public figure, or even a limited public figure. And this is interesting. As I was thinking about this, preparing for the show, Denise, I remember you asked me a question along these lines way back in 2006 when I was speaking at a conference out in San Francisco about, defamation and Section 230. And that was the very first time I had thought of this. Could a blogger or something be a micro celebrity to such an extent that they become a public figure? And I think that the sensible way of looking at this is to realize why we treat public figures differently. And that is, it's a pretty sophisticated question, and it kind of even goes back to what Jeremy Bentham said about public discourse and stuff way back in the 17th or 18th century. Or 19th century, right? And it's because these people who put themselves or otherwise find themselves in the public arena should be subject to a greater level of public scrutiny, and those who choose to critique public figures in this way should be given more leeway. Now, that, as with so many principles, has as its foundation the notion of the public interest and a positive aspect of the public interest. These days, things are different than they were when the case, like the New York Times case that kind of established the standard, requiring actual malice when you are a public figure going after someone. Times are different now because the tools that we have available to us allow many more people to attain the status of micro celebrity. And so what does it really mean? Well, it may mean that you're very well known, and there's a lot known about you by a small group of people, and you may traditionally be considered a limited purpose public figure. When I think of limited purpose public figure, I think of someone like Cindy Sheehan. I think she's a great example, and I didn't develop her as an example. I think maybe we've talked about her as an example of this kind of limited purpose public figure on the show before.
Remind me who she is.
She is she's the one who hated George Bush more than anyone else on the planet. Remember, she was that anti-war. She was the mother of her son died in Iraq, and so she was just extremely vocal against the war in Iraq and went down to all this stuff. Okay, so So with all of this said, what we have is a situation where we need to keep these principles in mind, given the fact that there is, the threat. I guess what I'm trying to say is the threshold for being well known should be a little bit higher these days, since there is the ability for more people to become well known, and we can't apply the same sensibilities as what we did, back in the old days, than these days when everybody can be famous for, not just 15 minutes, but maybe 17, 18, 20 minutes.
Right. There's a couple of things interesting in this case to me. Number one is, Kashmir, you alluded to Courtney Love's insanity by social media defense, which reminds me of something we were talking about, I think, on the last TWiL, where, the whole context of social media encourages people to say things that they wouldn't say to people's faces necessarily, and to say them in a durable, searchable way. And also the notion that, we've been talking about the degradation of privacy in some way, and the way people's privacy expectations are morphing, and, the whole notion that one kind of person could be a public figure while others with public presences would not be, seems to be in flux and perhaps going by the wayside. Marty, any thoughts on either of those points?
First off, I want to agree with Evan about going back to the purpose of the public figure. Do you hear that noise, Denise?
Yeah, I don't know where that's coming from.
Sorry, it might be the Forbes office. I apologize.
Right.
That's okay.
So first off, again, you have to go back to Times v. Sullivan, which is the case that created that actual malice standard. And there you had a truly public figure and an interest. It had to do with a sheriff in the South during the civil rights dispute, a truly public figure suing a news organ, the New York Times. And in this situation where you have a very questionable public figure suing someone who is not really a news organ at all. So this seems like a very kind of inappropriate use of the public figure actual malice standard. I do, however, agree with your concept that these micro-celebrities, or to paraphrase, people who are going to be famous to at least 15 people, that it can be a situation where they are a public figure. Now, with regarding to the degradation of privacy, when I look at my 12-year-old and my 14-year-old on Facebook, they clearly have a different idea of privacy. I think they are embarrassed by less, and I think that the concepts of what is per se defamatory is going to be different when they're adults than what it is to us.
Right. Well, I want to get into talking about how folks are finding their personal information discovered by people they're not expecting to be looking for it after the break. But I also want to talk about our sponsor for this episode of TWiL, Squarespace.com. And actually, I mean, this goes right along with what we're saying. One of the best ways to control what's being said about you online is to have your own online presence and have that be the definitive place for information about you. And Squarespace is a great way to set up that kind of presence. It's really, really wonderful and easy to use. It is the easiest way to publish a high-quality website or blog. Its UI for creating and managing a site or a blog is really beyond compare. I mean, it's so wonderful and easy and flexible. Whether you're a beginner or someone who's a CSS expert, it's going to have everything that you need. There are hundreds of beautiful templates to choose from that then you can tweak and customize to your heart's content, really make it your own unique presence on the web. It's an all-inclusive service that gives you modules to build your website, including a blog module, a form builder, Flickr photo display, a whole gallery for photos if that's what you'd like to do, widgets to bring in all the social media things that tie into your life, Twitter, Facebook, and everything else, Google Maps, and more. One feature that I really have explored and been impressed with lately, I was helping a friend of mine set up her Squarespace site, which you can check out at lorrisworld.com, LORRISWORLD. If you want to check out something that we just put together very quickly and easily, it's a great example of what you can do without a huge time or expense commitment, and yet it's a really nice looking site. And one of the things we did was give her a custom domain name. And, you know, we've talked, Hover is another frequent sponsor of the show, and we've talked about how nice all of their FAQs and help pages are for managing domain things. Squarespace does a ton of this too, because what it does is have a whole module that enables you to put in what your custom domain name is, and then it troubleshoots it for you. So if you haven't set up something properly, if, you know, I don't know if people have done a lot of the tweaking behind the scenes of getting their domain names up and redirected, et cetera, but it can be like speaking an entirely different language when you have to decide, you know, what the name servers should say, and I don't even know what all the various fields are called anymore. But Squarespace troubleshoots it all for you. It goes and it looks at that domain and it makes sure that everything's pointing to the Squarespace sites properly. And if it's not, it tells you what to fix. So that's just incredibly valuable and makes it even easier to use. Its cloud architecture for speed and site stability makes it so that if you get slash-dotted or otherwise have a ton of traffic coming to your site, you're going to stay up and rock solid. Its Ajax interface to drag and drop things around is incredibly intuitive. And it's got an iPhone and iPad app now, working on an Android app so that you can keep everything up to date when you're on the go. Use Squarespace for all of your website needs. Build it, host it, and update it anytime. For a 14-day free trial, go to squarespace.com. Sign up for a free account. You don't need a credit card. You just try it out. It's the fully featured version of Squarespace during your trial period. And then if you want it, you just tell them, yep, this is great. And they sign you up. So we thank you so much for Squarespace for sponsoring the show and encourage you to go check them out and give them a try. Okay, so one of the people who a litigant probably didn't expect to be checking out a Squarespace page, a Facebook page, was the judge in the case. Evan, you want to tell us what happened there?
It was a Social Security disability case in federal court in New Jersey, the District Court of New Jersey. That's in federal court. And I'm certainly not expert on the procedure here, but I know that there was a proceeding within the Social Security office. The question was whether this woman is entitled to disability benefits. You know, she's disabled, can't work because of her asthma. So the administrative law judge in the Social Security office determined that she was not disabled because of her asthma, and the woman who was seeking benefits appealed that decision to the federal court, the district court judge in the District of New Jersey. The district court judge, she determined that essentially the administrative law judge didn't do as much fact-finding as what he or she should have, so the district court judge sent it back to the Social Security office to do more fact-finding and all of this stuff. She remanded the case to the Social Security, to the commissioners, how you talk about it. That is a pretty vanilla kind of Social Security disability claims case. There's one interesting little piece of the case, though, and that comes in a footnote relatively late in the opinion, where the judge said something, and I'm not quoting it because I don't have it in front of me here, but said something like, although I'm remanding it back to the administrative law judge, I did note, or she used the third person as judges often do, the court noticed in doing its own research that plaintiff's Facebook page appears to show a picture of her smoking. Now, remember, the claim is she's disabled because she has asthma, so that could be a little bit problematic. So the judge went on to say, if indeed this turns out to be true, plaintiffs or the court is suspicious of plaintiffs' claims. So that is, really an intriguing little piece of information we get to the judge, or get from the judge here, and it could lead us to talk about a number of things. The first one kind of just being surprised, like, oh my gosh, judges are doing their own research like this, and you better watch out because not only your opponent is going to be looking at you, but the court itself. And so I've gotten some interesting comments on my blog where I wrote about this, and the theme kind of arises here is like, did the judge do something wrong by doing her own research? And I think that's something that's worth talking about, or worth at least thinking about, because aren't judges supposed to be impartial? That's this notion of impartiality is something that is really important to judicial integrity and judicial ethics. And the Code of Judicial Conduct talks about impartiality and how a judge should recuse himself or herself if he has personal knowledge or personal connection to the facts of the case. So, interesting
my double
for a
standard
number of
radar
reasons.
goes off with this one, because if a juror does this, and we've seen this time and time again, it results in a mistrial frequently. If a judge does it, it's just fine. What do you think, Marty?
Well, I think a couple of things. First off, judges are allowed to take judicial notice of stuff, and you're supposed to know what they're taking judicial notice of, and there's a limited amount of information that they're allowed to take judicial notice of. And I'm not quite sure that a single photo on Facebook might fall under that federal rules, what's proper for them to take notice of, although they did put the litigant on notice and the litigant has an opportunity to explain. Why can't a juror go do their own research? Well, because they're a juror and they're going to misunderstand what they see, and the judge is always allowed to obtain a whole lot more evidence than a juror. I think this goes back to a lot of the themes that we've been talking about this entire hour, which is, what are our expectations of privacy in this day and age? Also, once something is out there, it's out there. And maybe the rules to deal with this has to do with, for example, admissibility. We can say, look, if this information is released in a certain way, then it's not going to be admissible. And if my kid does stupid stuff on Facebook when he's 12, then a college admissions person can't look at it. Maybe the answer is Professor Lessig should expand his Creative Commons concept, that when you're making all of this information public on Twitter or Facebook or whatever, you're stating what your expectations of privacy are. In the olden days, if you walked outside your house and you were smoking and you had to prove that you had asthma, you were out of luck. But on the internet, you put on a Creative Commons privacy expectations tag, and that says, look, this is not admissible, or so on.
I don't know if that would fly. Kashmir, you think this guy was just a victim of Facebook's convoluted privacy settings menus?
Well, that's what I was wondering. I was wondering what kind of, I know it's administrative court, so I don't know what the representation was like, but it seems like every lawyer is now advising their clients to go through their social networking presence and look for any evidence that can be used against them and either take it down or, and I tell people just keep your privacy settings high. And it seems like, from my understanding, is that judges are starting to look at that what your privacy settings are matter. I think it's still evolving as I understand it, but since there are these very granular settings, if you've chosen to make it very private and people can't get to it, then that's supposed to be respected. But if you have it exposed, then it can certainly be used against you as long as there's not kind of subterfuge involved in getting that information.
Right. The law is always concerned with what one's reasonable expectation of privacy is. So, you know, if you've taken steps to try and lock things down, I could see a court being sympathetic to that. Except perhaps in the instance if you're walking around wearing social media eyeglasses, which is something that was written up over at ZDNet by Rich Harris, and it's from a company called Zion Eyes. And I'm not sure exactly what the things look like. Yeah, this must be them featured in Rich's story. They look like a pair of Ray-Bans. They look very innocuous. And their capability is to be able, you know, it's sort of the next generation iteration of a just-in-TV kind of live streaming situation where someone's walking around and they have a camera on their head, except for this time the camera is in their glasses. And it's much more subtle that way, I would think. And, you know, it's possible to go around and just record folks without them necessarily knowing what's going on or having any sort of affirmative consent to the fact that everything this person's doing is being streamed. Marty, any thoughts on this against the context of what we've been discussing?
Well, the only precedent I can think of is surreptitious recording. That is an example where I could admit to horrible crimes to you over the phone, as I have in the past, and that's not going to be admissible if you are recording it without my knowledge. And I think that's the first thing that came to mind when you pointed out that article to me.
Mm-hmm. Kashmir, do you think that this is the death of privacy as we know it, or just something that a fringe element of folks will pick up and use?
I'm trying to figure out exactly how it's different from just all of the video taking that we're doing nowadays. I was looking at a company called LifeLab, and you put your iPhone in your kind of like front pocket, and it just takes photos every 30 seconds or 3 minutes. It seems like this kind of constant filming is just becoming ubiquitous. What I guess what I found more disturbing recently is this spate of surreptitious videos. This keeps happening with Planned Parenthood and then with NPR, where it feels like you almost have to be expecting that you may be filmed at any moment. And it's similar to your online presence, that you should expect that somebody is going to Google you. It almost feels like you should expect that you may be tape recorded at all times of your day.
Right. Evan, any thoughts?
Yeah, along those lines. I mean, I like talking about this notion of social media being an integrity enhancer. And, you know, because think about, and I've used this example before, think about the photos of yourself appearing on Facebook doing a keg stand. There are two decision points. One was in putting the photo onto Facebook, you know, when your friend did that. And the other decision point was when you decided to do the keg stand in the first place. So doesn't this remind us that we're supposed to go around kind of having good manners anyway? Maybe it's just that it's more of a question of accountability now. You know, if you're walking down the street and you're, you know, doing something embarrassing like picking your nose, you know, you may have 5 people see you. Well, maybe now that could be, you know, 500 or more, and it could be memorialized and all that stuff. So maybe all of this stuff is just making us better people. Right, Marty?
No, I actually very much vehemently disagree with what you just said. And that is one of the things that makes life worth living is that there are places that you could create for yourself where you can do keg stands.
Those are called houses.
Yes, maybe the photo was taken in a private house. I certainly agree with you that the decision to upload the photo is a different sort of decision. But one person's accountability is another person's fascism. So I really vehemently don't like the idea that we can be secretly taped at any given moment, and that's somehow going to create something that someone's going to refer to as good behavior. So,
yeah,
sorry,
yeah.
disagree.
Right.
Well,
Flute
and
in
you know,
the
I don't disagree with what you're saying either.
I've heard some young people are having parties now, and they have a kind of you check your smartphone at the door so that people can't take photos and can't make videos, and you can just have a space where you know you're not being recorded unless somebody sneaks it in.
This is awesome. So we have now a parallel between kid parties and federal court, because either way you can't take your phone in.
You know,
Awesome.
very often you'll see bloggers talk about conferences that they've attended or important meetings, and they will indicate that they had agreed to a no live blogging rule when they attended the conference, where there's this understanding that people are going to speak more freely if they know that they're not going to be blogged. So there is a lot of situations, and I guess WikiLeaks kind of proves this, that there can be more free flow of information when we do have a contractual understanding as to privacy. So, I mean, I absolutely agree that people will do fewer stupid things if they think that their parents are going to find out about it on Facebook. But we can't have a situation where there's no confidentiality. And we saw that argument made in the context of WikiLeaks. Confidentiality and privacy can enhance the flow of information.
Right.
Look at attorney-client privilege.
I was trying to say, Floop in the chat room pointed out that these things would be perfect if you wanted to record your arrest or traffic stop or what have you, but there is a flood of controversy about whether that is illegal wiretapping from the law enforcement agencies, and that's still sort of all in flux. So, Marty, we are rapidly needing to bring this in so that we can get tech news today on Hard After TWiL. But very quickly, can you tell us about the new AdWords case from the Ninth Circuit?
Very important case, important to anyone who advertises, but I think you're going to appreciate the whole internet law aspect of it. Network Automations is the defendant, Ninth Circuit case that came out 2 days ago. It was the reversal of a preliminary injunction where the defendant had purchased a competitor's trademark as a keyword and ran a somewhat neutral keyword ad. In other words, they were head-to-head competitors, and the ad just had generic terms for that sort of product. And they had been enjoined at the district court level, and the Ninth Circuit has reversed. And the most important thing is that it takes a case from 10 years ago, the Movie Buff decision, which sort of enhanced this concept of initial interest confusion, which is sort of like, oops, made you look confusion, where you have like a meta tag or a keyword of your competitor. They wind up on your site, so you get sort of a free eyeball. And through the context, they're not confused. It's apparent who they are. 10 years ago, they said that is actionable trademark infringement. This time around, they said, nope, we're even going to name the case, and it's sort of like reversing without saying you're reversing it. So that's Network Automation, Ninth Circuit, the beginning of the end, perhaps, to initial interest confusion as a doctrine for trademark protection on the internet.
Right. And we have a ton of interesting trademark stuff to go through with Marty, but just not the time to do it on this episode of TWiL. So I'm hoping, Marty, we can have you back on again soon. We'll check calendars after the show and go through some of the other stuff.
We have the graphics ready, so sure.
I know, we have the graphics ready. We got to get you on again soon. But we're going to move right now to our tip of the week, which is right in line with all this talk of videotaping and photographing. And this also comes my way from Marty's blog, that soon in Florida, it could be a felony to photograph a farm. And folks seem to be speculating that this is a reaction to PETA folks coming and trying to gather evidence of cruelty to animals and make that public. And now there is some legislation pending that would actually make it a felony to try and gather that kind of information. So our tip, I guess, is be careful what you photograph in Florida. And if you're making it livestock, be particularly careful. Marty, any more texture you want to add to that?
Well, the bill was inartfully drafted. So what they actually did is make it a felony to trespass on a farm, and they're making it a felony to take a photograph of a farm, even if you're not on the farm itself. So, for example, Google Earth, if you're out there, do not take pictures of any farms in Florida. If this bill is passed, it's a felony, and you're going to do hard time.
Youch. All right, and we've got a couple of good resources of the week as well. The first is quite a humorous one from our friend Eric Gardner over at The Hollywood Reporter Esquire. He has a great post that I encourage people to go check out called The Top 10 Legal Disclaimers in Hollywood History. Legal disclaimers are always fun to unpack, and these are no exception. One of the briefer ones is from the movie Borat. Selling piratings of this movie disc will result in punishment by crushing.
Nice.
Similar other actual legal disclaimers used in Hollywood. So go check them out over at Eric's blog. And then a more useful resource of the week, perhaps, is, let's see, let me pull it up so I get the exact right name. It is a new blog from New York Law School's School of Law and Journalism, and it is called Legal as She Is Spoke, which I think is a play on English as She Is Spoke, which is a way of saying they're going to try and interpret the law of law and journalism. And it looks like a great resource, and lots of contributors over there, and encourage you to go check them out. And you're going to have a closer opportunity to check out some of their contributors, as a slew of them are going to come on TWiL over the ensuing next few weeks. So we look forward to seeing them. And in the meantime, check out their blog at Legal as She Is Spoke. And with that, I'm just going to go around once and have you guys sign off. Tell us any last thoughts you may have about the stories we talked about today, or anything else that's on your mind. Kashmir?
Thanks for having me. It was fun having you guys in my Forbes cubicle.
Yes. We're delighted to be there.
I mean, I guess one thing I kind of was left thinking about with Courtney Love is just this idea of kind of publication, and how Twitter is this kind of strange mix of conversation that we have and then an actual kind of published news source, and how that's kind of how that changes the defamation claims. I think that's something I'll be thinking about moving forward from this call.
Yeah, that's a fascinating point. And in the meantime, we can see you flesh out those thoughts on your blog, The Not So Private Parts, at Forbes, and folks can follow you on Twitter at Cachefly. Thanks so much. Great. All right, Marty, great to see you again. And again, we're going to need to have you back on soon to try and unpack the other interesting recent trademark developments. In the meantime, folks can check Marty out at schwimmerlegal.com and at Trademark blog on Twitter. Any other thoughts?
I think the real solution to privacy is to lie. I think you should give misinformation about yourself on Twitter and Facebook. It's obvious.
All right, we'll make that our second tip of the week, I guess. You heard it here from a legitimate member of the New York bar.
Semi-legitimate.
Semi-legitimate. All right, thanks again, Marty. And Evan, great to have you back on the show as always. Any concluding thoughts?
Oh no, I've already exhausted everything I know for the day. But it was a lot of fun. It's always good to talk with you, Kashmir, and Marty. It's always great. So really had a great time. Thanks for having me.
Great to see you again. And folks should check out Evan at internetcases.com and Internet Cases on Twitter. And you guys should all check out, of course, when we record live on Fridays, live.twit.tv. If you're listening to this after the fact in a video or audio fashion, it's really fun to listen to us live and come participate in the chat, irc.twit.tv or pound IRC in your IRC, pound twit live in your IRC client. And we post up questions before the show at Facebook, facebook.com/thisweekinlaw. Love to get your feedback there. And with that, we'll wrap up TWiL 102. Thanks so much for joining us, and we'll see you next week.